in the freedom of expression. I don't know if there are many people in the world, but I'm one of those guys who think that there should be no exceptions to the freedom of expression. Like, I should just say whatever they want to say. I don't think that is as bad as limiting freedom of expression. But back at law school, we were told that the freedom of expression guaranteed every other freedom. It's easier to steal property of a widow if you also first of all guard the widow from speaking up. So I agree with that notion, and I think that is true. But also, at a personal level, hey, I speak quite a bit. I am very expressive. I say my mind, and so that's why I believe in this freedom. Now, where we start is that I work with an organization that tried to document the cases of people who were affected by this law. And there are quite a number of them. I think from our estimation, maybe anywhere from 50 to 200 people were arrested. 50 to 200 people were arrested, sometimes abducted in regard to this law. And many of them held a number of days. You know, there's this policy where they just pick up people, hold them for a couple of days, and then release them. Now, it doesn't, if you look at it, it's not as bad as holding someone in jail and maybe convicting them and all. But for the ordinary people, that is very, very impactful. It creates this picture of fear, which I think the state has, to a good extent, to a great extent, succeeded in achieving with the Ugandan populace. So I'll just give you a few names. There are people like Edward Awewa, the 24-year-old. So Edward Awewa's story is very sad, and I'll come back to it. There are people like Emmanuel Nabodi, who was jailed for 2 years, that was in November 2024. There's David Sembozi, a 21-year-old. I think on TikTok is called Lucky Choice. There is Sekagiri Isaiah, there is Julius Nayewa, there is Fred Muganga, who is 26-year-old. There is Waswa Noah. And last year, around this time last year, there was a lady arrested called Pasi Mbabazi. She's a member of the National Unity Platform under this law. And there was a bizarre, weird, and disturbing case of a gentleman called Elson Zumwene. Elson is a 21 or 22-year-old student of Makerere University who was placed for his internship. I think it was at the School of Agriculture, placed for his internship in Hoima. The Ugandan state tracked him from Hoima, disappeared him for about a month, if not longer, and then he later turned up in court, accused of, among other things, insulting the president, insulting Mwosi. And at the start of this year as well, there was a gentleman called Odor James. His alias is Don Amis. Now, I'll go back to the case I started with. That is the one of Edward Awewa. Edward Awewa was picked from Mukono, taken to the magistrate's court, charged, forced, not, let me say coerced to plead guilty. He pleaded guilty, and as we speak right now, he's in the second of his 7-year sentence at a prison in Adjumani. I come from Westline. Westline is the other side. I mean, I envy my friends who say that I'm going to the village, then they say, yeah, I'm going to Akiso, which is my village. Now, when I'm going to my village, I need to plan for a week to go to my village. And it's a whole day's drive with a lot of prayer, because for that distance, a lot of things can happen along the way. But they picked this gentleman from Okono and took him that far. When we made contact with him last year, he told us that it's the first time I've received visitors in prison. His requests included things like slippers. Said, can I just have some pocket money? We said, how much pocket money you need? Say 15,000. So I said this to say that this law, while we talk about it from the abstract and from the legal books and from all this, there is reality on the ground that there are people it has caused untold suffering. Edward happens to be from Mukono. He has never been to Arua. His family is very humble, more humble than most of us here. They are able to mobilize transport to go and check on him in Adjumani because, like I said, it takes a lot of money to go that far. It takes a whole day's plan. So, for people like that, and for people who end up in these situations, first of all, this is a reprieve. And again, let's not kid ourselves. We are at a situation as a country where, with or without the Computer Misuse Act, there is a wrong regime that can do this. Right? That is the starting point. So it's good to celebrate this. It's very important that this was struck down. We see how the days go. Like it's been said already, it's likely that there's going to be a stay of execution. It's likely that there's going to be another law passed. If you have a House of Parliament that is led by a person who publicly says the president that no one understands the value except you, a person who says you just tell me how high to jump and I will jump. That is a very, very disturbing set of affairs. This law is not detached from the reality of Uganda today. It's in those circumstances that we have this law passed and fortunately struck down by the Constitutional Court, but of course there can be an appeal to the Supreme Court. And also, when you look at this law talks to how our leaders view power. I've read many of these charge sheets, I've looked at them, and there is a disturbing pattern. One, they find one particular magistrate's court where almost all these guys are taken. In 2024, it was a Germany. The magistrate there was Stella Maris Amabilis. It was like there was a revolving door between wherever you're picked, in police post, the court, and jail. It's like there was that revolving door. You just have to find yourself in those three places. And yes, these are our young brothers, many of them uneducated, many of them of less means than us, many of them couldn't afford a lawyer like Aaron Kiza here, like some of you can. So what they do is, on the first instance, they're taken to court, they're all crying, they're all pleading and saying, I will not do it again. And in the case of Edward, for instance, Stella Maris Amabilis was that, I know you pleaded guilty, I know you act remorseful, but I'll give you 7 years to make it as a lesson to the rest of the people. So for me, here is the thing. It's a sad state of affairs. But I want to add my voice to other calls spoken earlier that with initiatives like this, we can make some progress. We've already made progress that the law has been struck down, despite that being on technical grounds. But there's much more we can do. And if each of us pulls our weight as Ugandans, maybe that law will never come for me. I mean, I'm not saying it won't, it can today. I can be charged under that law for things that I've said now. It doesn't matter that the law was struck down, because we live in a country where wrong people can do whatever they want and they will point to the law even wrongly. But if we all pull our weight, if we all do things like we're doing here, and that is why, for instance, Agora, for instance, we try to do our part, and I would just say that we have a Twitter space today, 7 to 9, where Isaac Semakade is confirmed as a panelist, and we're talking about this law. But if all of us pull our weight, that's going to be a big deal. For those who have already been convicted, now we should finally, sorry that I passed. After a second, sorry that I passed through Kenya to get to your question. But to your question right now, I think we need to appeal many of them. I don't think, like Aaron said, the magistrates courts are just going to release these people. Whenever the name Muhozi, the name Museveni, the name Anita Mong are mentioned as the victims, quote unquote, even though they never come to court, my fear is that most of the magistrates, they just cower and they cannot take any further steps. Thank you.
The court has confirmed its decision in Wakiso, Beer Growers and Dealer Association on the duty cast on the speaker to ascertain quorum before a constitutional body parliament. That is a material safeguard. It's called a guardrail of the constitution, constitutionalism, and so on and so forth. Colleagues, it is not easy for parliament to marshal quorum under the test the court established in Wakisoya Grower. It's not easy. The court insists that every vote must have 5 items: the number of parliamentarians present, how many of them are ex officio, so that we can then know how many of them are entitled to vote. And of those who are entitled to vote, how many have voted yes in favor, how many have voted no, and how many have abstained. That numerical record must be ascertained in the hazard against the decision of the speaker. The way we see it in the US Congress and the way we see it in the House of Lords. The court, for a long time, Parliament has used other means. So that insistence, the court holding that what I say, we are going to keep this guideline. Don't take us for granted. That's a massive step change. Was a massive step change. It built on an earlier test, the Tokers test, which had used more the electoral language, it has disapproved the use of a yes and no. That says we don't think that convention can pass the test written in the law under Article 89. But nonetheless, the law. So that guardrail is a citizen's victory that is substantial. The second one on substantive is doctrinal purity, doctrinal clarity, simplification of these principles on freedom of speech. They are easy. So yes, here I would like to disagree with my colleagues, Advocate Chiza and Mr. Latif Tony. But there is not a significant step change on the substance. Despite, first of all, the case of Ogo was the tip of the spear for freedom of speech, freedom of expression, freedom of opinion in Uganda, and I believe the English-speaking judiciaries of the global south. It's that important. That's why even Kenya recited, Africa recited. So its major contribution was that democracy must mean the same thing to all signatories to the UN Charter. There must be no accommodation for local circumstances when we are defining the tenets of democracy, including freedom of expression. But as long as Uganda signed on to the UN Charter, the International Covenant of Political Rights, its aspirations, its binding aspirations for the citizens of Uganda must be the same as those in quote-unquote mature democracies. So that with democracy, there's no catching up. So I think the government had appealed, arguing that it should be permitted a wider margin of appreciation to determine how much democracy to permit Ugandans that are being required to allow so much democracy. Is not the meaning of the covenant. The court said no. We disagree. You can't prove that you need an exception under Article 43. Although human rights are not absolute, freedom of expression is absolute, the guardrails that are accepted internationally must also be obeyed by you. So you will not depart from the standards we need whenever you want. So, that decision, every decision suffers wear and tear. So everyone is right that in 2023, on the 6th of January, in the Calamity decision, the Court of Appeal, revives that and says that we hold firm to the standard in our law against the law. So, I'm just a couple of did justice, but yes, I agree. So what then is the step change here? The step change then here is that it's twofold, and colleagues Aaron Natif hear me out. The first one is the order of the legal judgment here. It is neither, first of all, it's a woman. That's a significant observation. And which kind of woman? Justice Muyabonya Aileen has not been a friend of freedom of expression. If you have ever been around her, you know her personally. She is a liberal dandy. She is a princess. This piety, Victorian piety. So there's a judgment, legal Christmas Master General. Constitutional petition number 23 of 2015. Legal Christmas and Simon Kakwanja and Brian Takai we were asking for, what are they called? Open vetting, that there should be open vetting at Parliament for leaders. That's the argument. She said so many words, but the political substance, she said, media exposed to the vetting of leaders, especially judges, it will create memes. It will create memes out of our participation. And some of us don't like to be memed. So some of us will be threatened, will fear apply. So let the process remain under darkness. So this is the same way that this video was issued in 2023. So when justice now, so for her to now make a step change, it is significant. And many other ladies, I think even Sadam Bayo and others are not really, they don't belong to the cluster of the deceased Jikapu and Mulenga. The second thing is the material she has used. So she has introduced general comment number 34 of the Human Rights Committee and the 2019 Declaration of Principles on Freedom of Expression and Access to Information by the African Commission on Human Rights as the yardsticks for testing state compliance. Now that simplifies battle. In other words, now we don't need to cite authorities from anywhere and so on. We don't need to do so much work. This access to knowledge has been simplified. You see, Justice Mulenga had a lot of work to do, a lot of authorities to survey. Justice Mulenga has simplified it. She has said no more traversing the several jurisprudences. Let us use agreed upon clarification documents. The Human Rights Commission has clarified Article 19 of the International Covenant on Civil and Political Rights on Freedom of Expression. It says these are the rules. Did you follow them? If you did, we nullify. Then African Commission principles. When you look at those documents, they are written in plain English, is and was for a common man, for the lowest teacher, because of course these documents, to simplify translation, so that nothing is lost in translation. So that's a big step change for jurisprudential. I want to offer an example, and I ask that they post something for you to see for yourselves. Allow me some time here. Can the technology people post something? I ask them to post. Just to read general comment number 34. What is in there? I would like someone in the room just to read that thing and understand. So these are things that have been hidden. You try to operate a magistrate, but now this is so clear. So this helps us to, it's a guideline against malicious prosecution and so on and so forth. We don't need so much. This court has said there are two documents, this thing and this one. So in defense of the right to insult and offend, they said these things are opinion. If someone can help me in the room there and just read on the paragraph, you see it. Now this is law. It says paragraph of the opinion without appearance. This right against no exception, no restriction. So opinion.
Mr. President, let me read. Freedom of opinion
shall no longer need interpretation. You will just go to a magistrate and challenge right there under that act. Because the interpretation is now clear. I beg to submit at this point. So that's massive in terms of jurisprudence.
Thank you. Thank you, Mr. President. That is properly understood. Thank you for taking the time.
The President has just said it all.
You can say
I just want to emphasize the issue of quorum. And the court was very clear about guesswork. We are tired of the parliament that relies on the guesswork to determine quorum. I think that must stop. That's what the Constitutional Court is saying. And that's what the logic demands. There is another sign of evidence that the lead judge was indeed going into some kind of metamorphosis. That this is the judge who had upheld cyber stalking. Remember, cyber stalking is still part of our law. And I think her judgment, I forget the case, Garawambo, is a judgment in which the Constitutional Court, I hope it was appealed, but the cyber stalking is still the 2011 Computer Misuse Act, and that is still a problem. Again, jurisprudential, this judgment is a watershed moment. I have no doubt about this. I think, and we have not supplement there. All I was saying that we Ugandan functionaries have a habit of doing illegal things. 48 hours, police get us detained beyond 48 hours, but still we need good laws, we need good judgments like this to push back, because they are very big arsenal in the hands of those who are fighting for freedom. So we really appreciate this. The other thing that this judgment has done, relating not just to digital rights but to human rights generally, is it's not that it's entirely novel, but they have succinctly clarified the application of international law, one as an interpretative guide to constitutional litigation, but also any court should be able to rely on the International Bill of Rights, the United Nations Declaration, the 48th law, the 1966 Covenant, ICCPR, and the Covenant on Social, Economic, and Cultural Rights. The judgment, in an interesting way, simplifies how courts can rely on them as part of our law, since they have really assigned them congruent with the Constitution. Why I said that I think, so the judgment, again, in your question of digital rights, does a big, to use Isaac's words of step change. It's a step change for digital rights. It has put to bed, there was a retrogressive judgment in Wembo's case, which had saved criminal defamation. I think this judgment now buries it, and we no longer have criminal defamation in Uganda as part of our law. They used the creative element about it in this judgment. This judgment was the Constitutional Court's way of saying that they are sorry for the wrong decision they reached in the Wembo case about the decision. And I'm happy that they have repented. And so repetition, as again the judgment clearly said, can be protected through civil remedies. If I annoy you, and some of you are bound to annoy you, unfortunately our friend is in prison. He has been annoying me, you know that very well. But I don't want him to be in prison. You guys, we should be able to annoy each other, abuse each other, and because we are in a civilized society, in a democracy, no one should detain another. No, that's overreach. If I annoy you, ask me for money, I will pay you. If I delay paying you, sue me, or be patient with me. But this business of someone annoying you by abusing, and for you, because you are in power, you detain them, is not just unconstitutional, but also a kick. But I said this law was, after all, superfluous and unnecessary, because we have a Privacy Act. So what was this law trying to do? So on the ground of the fact that it was unnecessary, it would have been annulled, but they didn't even get there, because the column, they didn't have it. For freedom of expression, as the Andromeda judgment said, the overall decision is the encyclopedia. There we have not, and of course, the international jurisprudence, the declaration, African Declaration. I think this judgment is good for freedom of expression. It's good to, it does not threaten privacy. Privacy is being protected. Reputations are protected enough. We don't need criminal sanctions protect reputations. Is there anything else that about digital rights? So the only remaining thorn in the flesh of digital rights maybe is cyber stalking. And just like we have done away with the criminal defamation, finally we have to get a way around cyber stalking because I think it's still part of the old Computer Misuse Act. Thank you very much.
Information Festival Chair Director, Mr. Tony Galan, the Tokers Chair, your co-chair. And I told him that you see this panel is a team of rivals. Because we are a sentinel for internet freedom. And I'm very grateful to all my colleagues that they have come. Because we are the embodiment that you can agree. We have annoyed and insulted and abused each other, but that will be the reason for us to stay away from coming to say, you know what, this thing, even we are oh my goodness, wrong. Stop. Go open the door. So anyway, the point I'm making is this is it. So your answer is yours here. But maybe in the next steps is how we get the proof of that pudding is in the eating. What are the next steps? I think, and I'm grateful to what my brother has shared with me, that we are thinking on the same wavelength. It Tokers invited me also to a space at Angola happening at 7. And I said, well, I should be there because we should be working together now. I will differ a little from Native. Put me very close. And you can't say that all of us propaganda, we are saying.
No, I think I will speak, but I know
So you take for making it point because we are here, we are fighting all this battle for Muslims. The right to insult and I know you're not going there. I mean, lawyers who you think are going to need, like what they need. They wanted a radical new bar. They said, go and bar the devil and get us back on track. So we are ready to be a rights-based digital territory. The guardrails are too strong. These people, okay, the skepticism and the people you have expressed, we shall deal with it, but at least we know that we have this important commitment. And our judiciary, as my brother Andrew said, it can work out. So I want to put one thing, I think it's unity of purpose. Number one, number two, consequences. I have been critical of Angola and many other colleagues in the sector, not because of something personal, but I have argued before that I doubt you have ever had a seminar on something called consequences in a constitutional or cultural democracy. That's all. That was my whole bit. I remember there you need saying that I don't like working with others. So that's me wrong. I was simply saying that for us to build that act, we will have to be able to sit in a circle, the way we have done today, without cameras, without others, that we say we are convened here to build that act, to bring consequences in our lifetime, in a meaningful way, especially for Ibrahim Musata. You can do for him a poster, you can make that thing, but it's not enough. Your ability to say, you know what? I am Agatha. If I picked up a call and I say, Isaac, let us convene for Musana. Let us put aside everything and make Musana the poster for everything we believe in. That's called evaluated. Can we be evaluated? But why is it so easy? So for me, and I think this is a good starting point, we shall do much more in the Agora space, but I want to say, and I want to invite all lawyers, all colleagues, lawyers or non-lawyers, to read out something called consequences or consequentialism in constitutionalism. I think that's what they've all been talking about. This one saying that, oh no, power is unbeatable. They will ignore and allow everything. You can say that. That's because the conversation is in consequences. So we are one doctrine. Muriabona, who was our enemy in December, is now our friend. We are one. Yes, I was work, and so on and so forth. So, but now how do we manage such things? That's the catch, and I think we shall continue more in the Agora space. Thank you very much.
Thank you, Mr. President.
And center the public interest and eschew temptations to try to feather their nests at the altar, to feather their nests at the expense of Ugandans. They have to be patriotic, by which I mean they must be loyal to the country and the constitution and the values that define Uganda, rather than being loyal to their stomachs, being loyal to their egos, and being fearful. They must stop being fearful. They need to know that there is a Uganda beyond Museveni, there is a Uganda beyond the CDF, and they need to be courageous and defend Uganda, knowing that Ugandans are behind them. They need to also pleasantly surprise us, the way some of these judges have pleasantly surprised us in this decision. We have very low expectations of this parliament. We want parliament to shock us, to give us a pleasant surprise. That you people whom we hold in very low esteem, about whom we have almost zero expectations, we want you to deliver the things for the country and show that you love this country and that you're fearless. Then, if we have a fearless, well-meaning, patriotic parliament and patriotic parliamentary leadership, we shall not have a speaker who relies on guesswork to establish quorum. No, that will stop. So I think it is foundational values they need to. The problem with parliament is attitudinal. It has to do with greed and it has to do with fear. Stop the fear and be courageous. Have foresight, stop being myopic, and surprise us. I think I've combined my parting shots. Thank you very much.
Yeah, surprise.